Hello everyone, welcome back to our channel Law Point. This is your host Rita Thomas back again. When disagreements emerge over mortgages, whether you're the borrower, that is the mortgager, or you're the lender, that is the mortgagee, heading to court is often the solution. But here's the catch. There is a ticking clock. The law sets specific time limits for taking the matter to the court. Today, let's unravel the time frames mandated by the law, guiding both the mortgagors and the mortgagees in their journey through legal resolution. We have with us Mrs. Praseena Elizabeth Joseph, advocate on record from the Supreme Court of India, to explain the same. So let's watch this episode.
Section 61, 62 and 63 of the Indian Limitation Act deals with limitation period with respect to mortgages. If a mortgager wishes to redeem or recover possession of the mortgaged property, then he must do so within 30 years from the date the right to redeem or recover possession arises. This right arises when this mortgager, that is the borrower, pays off the mortgage debt. For example, Mr. Smith is a mortgager who borrowed money from the lender and he mortgaged his property to the lender. When he became financially stable, he pays off the mortgage debt. However, here the lender refuses to give back the ownership of the property back to the borrower, that is Mr. Smith. In this case, Mr. Smith can reclaim the possession of the property or the ownership of the property within 30 years from the date he pays off the mortgage debt and from the date the mortgagee refuses to hand over the ownership of the property back to the mortgager. Now there is another scenario where if the mortgaged property is sold by the mortgagee to a third party without the knowledge of the mortgager, who is the borrower, then the mortgager can reclaim that property. Then the time limit prescribed is 12 years from the date when the mortgager get to know about the transfer or the sale by the mortgagee to a third party. For example, here we will take the same case of Mr. Smith. Mr. Smith is a borrower or a mortgager who has taken money from a lender bank, and the lender bank here during the time of this mortgage has sold the mortgaged property to a third party. Now Mr. Smith might not have known about the transfer or the sale. Here Mr. Smith can file a suit for recovery of that particular mortgaged property within 12 years from the date he got to know about the transfer by the mortgagee bank in favor of a third party. Now there is a third scenario where if the mortgagee has collected surplus amount after the mortgage amount has been satisfied, then the mortgager can file a suit for recovery of the surplus amount within 3 years from the date the mortgage has been satisfied. For example, Mr. Smith, the mortgager, borrows 10 lakhs of rupees from mortgagee Mr. Y. Here the rate of interest of the mortgage was 6% per annum. If the mortgager pays off the 10 lakhs of rupees, the principal amount, with the 6% interest back to the lender, then the lender is supposed to take only the 10 lakhs of rupees plus 6% rate of interest per annum on that principal amount. However, if the lender is taking 8% as the rate of interest over the 10 lakhs of rupees, which was the principal amount, then the 2% over an addition to the agreed rate of interest, then the mortgager can claim the surplus amount within 3 years from the date he discovered about the surplus. Now there is a fourth scenario where Mr. Smith borrows 10 lakhs of rupees from Mr. Y and he agrees to pay back the amount through monthly installment for a period of 15 years. However, if Mr. Smith fails to pay the monthly installments, then Mr. Y can initiate legal proceedings to recover the amount from Mr. Smith within 12 years from the date Mr. Smith default on the monthly installment. Now we can see a fifth scenario where Mr. Smith borrows money from Mr. Y, 10 lakhs of rupees, and he agrees to pay back this amount within 10 years. The 10th year get over by 2024. However, if Mr. Smith fails to pay the amount within the 10 years, then the mortgagee, that is Mr. Y, can file a suit for foreclosing right of Mr. Smith from reclaiming back the ownership of the property. Here, Mr. Y can initiate such a legal proceeding within 30 years from the date this amount was originally due. Now from 2024 till 2054, Mr. Y can initiate legal proceedings, that is the suit for foreclosure, foreclosing the right of Mr. Smith from reclaiming back the property from Mr. Y. Now let's see sixth scenario where Mr. Smith borrows 10 lakhs of rupees from Mr. Y and he agrees to pay off the mortgage debt within 10 years. This 10th year get over by 2024. Here Mr. Smith, while taking the mortgage, has deposited the title deeds of his property in favor of Mr. Y. However, the possession of those property were with Mr. Smith himself. By 2024, if Mr. Smith fails to pay that mortgage amount, then within 12 years, that is 2036, Mr. Y can initiate legal proceedings to get back the possession of the property from Mr. Smith. Here, before concluding, one important aspect is in usufructory mortgage that we have seen in our previous class, there is no time limit prescribed for the mortgagor to pay back the mortgage amount. So, in case of usufructory mortgage, there is no limitation period which applies. Thank you.
Thank you for watching. Stay tuned.